Hi class, this is Alyssa along with Jaime, Andrea, Natalie, and Marie, and for our final group project, we will be going over Chapter 6, International Employment Law, Labor Standards, and Ethics. Thank you. The topics that we will be going over today are comparative law, termination and reduction in force, personal data and protection, anti-discrimination, immigration and visas, and intellectual property.
First, we are going to talk about comparative law. In the next slide, we have a little YouTube video explaining what is comparative law.
What is comparative law? Comparative law is the study of laws and legal systems in other countries. This form of law describes, analyzes and compares foreign legal systems, and is increasingly important in the trend toward globalization. It is essentially an academic study that both separately describes different legal systems and pits two or more legal systems against one another to determine the differences. Since French social commentator Montesquieu wrote his book De l'Esprit de Lois, or The Spirit of the Laws, on the importance of comparative law, several branches of this study have developed. These include constitutional law, civil law, commercial law, criminal law and administrative law. These fields of comparative law enable justice systems in every country to attempt to perfect their own legal system, to attain a greater understanding of the world and values outside their own country and, in some cases, aid in the different initiatives that work toward the unification of legal systems. Outside of a knowledge standpoint, comparative law is essential in improving and maintaining communication between different legal systems. Other than providing a structured means of intellectual exchange, it is also helpful in shaping foreign policies in different countries. This aids in streamlining the legal process for global businesses and the treatment of border-crossing criminals. While comparative law can and does compare the legal systems of two or more countries, the breakdown of legal systems is often much more complex. Countries of the world are typically broken down into families, though classification of these families varies. The oldest grouping in comparative law broke down the world into 7 families, including the French group, the German group, the Scandinavian group, the English group, the Russian group, the Islamic group and the Hindu group, with each of these groups encompassing a number of countries. Comparative law also often groups countries by their ideology. The simplest form of this puts countries into one of 5 families: Western law, Soviet law, Muslim law, Hindu law and Chinese law. Another version of this grouping focuses on both ideology and the history and sources of the laws in use. This form of comparative law groups countries into 6 categories: Roman, German, Anglo-American, Scandinavian, Far Eastern religion. With the increasing trend toward globalization and more countries moving toward industrialization, comparative law provides a gateway to understanding and cooperation. It not only allows individual countries a look into the workings and beliefs of their neighbors, but it also provides an overall look at humanity as a whole. From its inception in the 1700s, comparative law has continued to grow into one of the most important and relevant legal and humanities studies in the world.
The goals of comparative law. The overarching goal of comparative law is the accumulation of knowledge. The first goal of comparative law is to perfect a legal system. Comparative law is an école de vérité, furthering knowledge in order to produce the foundation for growth and supply of solutions, enabling legal systems to see where they can improve by providing examples. An important aspect to understanding a legal system, as David and Brickley put, it is to understand the internal matters of legal technique. Along with this, the external matters must be considered, such as political, philosophical, and economical considerations. The second goal of comparative law is to explain legal diversity. Legal diversity can be observed when studying almost any group of legal systems. There are systems which have similarities. They may have the same institutional structure. They may have similar roots, but the path each system has carved out over centuries of existence will involve many divergences. In order to explain legal diversity on a smaller scale, grouping together legal systems as Ziegler and Coates did into families will produce groups of legal systems with a similar heritage. For example, a group making up a legal family due to their basic in Roman law, such as the Romano-Germanic family identified by David and Berkeley, could be evaluated in terms of how they develop the system since then. Comparative law methodology. Comparative law must have a sound methodology to operate as a legal science. There are four critical parts to comparative methodology. The first part is acquiring the skill of a comparativist in order to evaluate law clearly, objectively, and neutrally. The second part is evaluation of the law as it is expressed concretely in words, action, or orality. We can refer to this as the external law. Once we get to an understanding of the law as it actually stated, we can move on to the third part of the methodology, an evaluation of how the law actually operates within a culture. We may refer to this as law in action or the internal law. Law in action is quite important, even to Western culture, as often the words in the take take on a different meaning as applied. Law in action is even more critical for non-Western culture, as here the law may be more a result of tradition, custom, or orality. To do this, we need to examine the underlying substructural elements within the culture that drive and influence the law. After we have evaluated the law as it stated and the law in action, we can assemble our data and conclude with comparative observations that can shed light on both a foreign and our own legal culture. Comparative law in France. In France, comparative law had a difficult stand due to the publication of the Code Civil in 1804. Accordingly, in the first half of the 19th century, French jurists adopted a strictly positive view, focusing entirely on the explicit wording of the Code Civil and its application. This system was very static and did not leave space for interpretation or development. France has a long and solid tradition of comparative law. As a legal science, comparative law has distinctive features in each country. While there is currently no such thing as French or Italian comparative law, in the sense that there is French or Italian contract law, there is an identifiable French style in comparative law that is closely related to the development of French legal thought in general.
Now we will be talking about termination and reduction in force.
Termination and reduction in force. Employment in France has protected classes where discrimination is prohibited. Sex, marital or family status, race and ethnic origin, religion or belief, sexual orientation, disability, age, equal pay for equal work. Employment at will, the employer with a few exceptions has the right to terminate an employer at will, and employer has the right to quit at any time, no matter the reason. Termination. Termination cannot be done on the grounds of health and safety, pregnancy or maternity, asserting a statutory right, union activity, or due to someone's gender, race, religion, or disability. Most countries' rights to terminate, lay off, reduce, restructure, move, outsource, or subcontract work is constrained. Reduction in force. They require notice and consultation. French laws require payment to employees, especially when a large number of layoffs are made. Business closures, workplace closures, diminishing economic need to work. All of the above require notification and a possible payout. France has an acquired right to his or her current work level, and their benefits pay cannot be reduced without consultation and notification.
The next category in comparative law will be personal data and protection. Personal data and protection privacy is an increasing concern that is present around the world, and it involves the sharing of distributing private, public, or firm information. This issue has significantly increased due to the high spread of the internet, making global communication so much easier. Privacy protections have been put in place when data is being shared, especially between Europe and the United States, to be reviewed and fall within compliance. This is to ensure the safety of data being accessed and to avoid any hackers or disturbance of obtained data. GDPR stands for General Data Protection Regulation. Europe has this protocol in place, and if the US were to not comply, they would lose rights to do business in the European region and are liable for any fines and misplacement of data without the privacy protection of it. Along with transferring data through protocols, search engines and the wide use of social media do not contain the spread of data. GDPR allows national laws to adapt or extend the provisions of the GDPR. French rules will apply to processing activities concerning data subjects residing in France, even if the data collector is not established in France. GDPR stands for General Data Protection Regulation. In the image below, it describes the main objectives of this data protection regulation. The main objective is to reinforce, which is substantially strengthen the rights of citizens by giving them more control over their personal data. Creditability, to increase awareness of data regulation through a system of penalties. Establish, introduce new rights for Europe nationals. And empowering, empower the actors involved in the data.
Our next slide is over anti-discrimination. Anti-discrimination laws in France. meaning to oppose or prevent discrimination against any person. Unfair treatment of someone because of their sex, race, age, religion, sexual orientation, or disability. Law of Equality in 2016. In 2016, France amended the Law of Equality of Rights and Opportunity for those working in this country. Equality, being equal, of the same status, and giving the same right and opportunity without discrimination. Anti-discrimination example. Many, if not all of you, have heard a lot about the Human Resource Department at work who carefully focuses on equal opportunity of employment to current and future employees. The Human Resource Department is divided into many different branches: payroll, recruiting and staffing, labor relations, benefits and compensation, training, and human resource compliance. Each of these branches can specifically handle the situation of an employee. In this case, a human resource representative must handle a situation that is over a discriminatory act. For example, let's say an employee reports to HR that their supervisor is treating them unfairly because of a physical disability they have. This employee states that they never have a chance to work in the front to speak with guests and is always scheduled to work in the back because the supervisor does not like that the employee has a stuttering disability. At this point, the employer is accusing the supervisor of a specific action and it must be investigated. So, exactly how must we handle this? Well, first, we must ask ourselves, is this a true act of discrimination? Does the supervisor have a history of discrimination? Does the reporting employee have a history of accusing towards others? What action must be taken to best help the work environment?
Our next slides will be over immigration and visas. There is a significant difference in French law between a simple visa and a long stay or a residence permit. They refer to their visas as stay documents. A long stay visa or entry permit is required for any person applying for a stay document. Applicant has to proceed by submitting an application with all supporting documents to a French consular authority and receive an approval to travel to France. No long-stay visa is required to stay in France for a period up to 90 days for nationals of the OECD member states and citizens of the US. Non-EU citizens, in order to stay in France for more than 3 months, must need a temporary residence permit, skills and talents resident card, or retired residence permit. A little further into stay documents, which are for immigrants who are visiting the Republic of France using a long stay visa and plan on staying in France for a longer period of time. Here are some of the criteria. They must validate their visa, which shall serve as a residence permit, or apply for a residence permit during their initial 3-month stay in France. There are 2 types of stay documents. The first one is a temporary residence permit, which remains valid up to a year. This stay document requires annual extension procedures in order for the applicant to stay in France for longer periods of time. The next permit is a residence permit, which is issued exclusively to highly qualified employees. This document is usually issued for a time period up to 3 years and is renewable upon expiration. The following slides will be over intellectual property. Intellectual property transactions in France. Intellectual
Patents.
property
To be
forms of
granted patent
employee
protection,
creations
an
such as
invention
patent
must comply with the
innovations,
patentability
discoveries,
requirements of the French
trademarks,
intellectual property
geographic indications,
(IPC).
industrial
Invention
and
must
product
be
design.
new, inventive,
Inventions and
capable
intellectual
of industrial
contributions which are a
application,
result of
and not
individuals'
excluded from
employment
patentable
are
subject matter.
considered employers'
To have a
property.
valid registered
Trade
trademark, a
secrets,
sign must
product,
be
process technologies,
distinctive,
and patents are either filed for
non-deceptive,
legal protection
lawful,
or
and
protected
available.
through non-disclosure agreements
Copyright.
with other employees.
To qualify for protection, a
Training
work must be
materials and
original,
product
that
manuals
is, bear the
that
imprint
employers
of its author.
develop for employees'
Copyright
use
arises
are
automatically from
copyrighted
the mere
in order
act
to
of
protect them
creation,
from outside use.
that is, no registration is required.
What is
Design
What
rights.
is
To
intellectual
qualify
property?
for protection, a French
Intellectual
design must be
property
novel and
forms
have
of employee
individual
creations
character.
such as patent
Functional
innovations,
forms and designs
discoveries,
contrary to
trademarks,
public policy
geographic
or morality
indications,
are excluded from
industrial
protection.
and product design.
Trade secrets and confidential
Inventions and
information.
intellectual
A
contributions
French
which are a
law
result of
implemented in
individuals'
May
employment
2018
are considered employers'
directive
property.
on the protection of
Trade
undisclosed
secrets,
know-how
product,
and business
process
information
technologies,
against their
and
unlawful
patents are either
acquisition.
filed for legal
Here's the
protection
criteria.
or
It is
protected through
not in itself
non-disclosure
or the
agreements
exact
with other
configuration
employees.
or generally known or
Training
easily
materials
accessible to
and
people
product
familiar
manuals
with this type
that
of information.
employers develop for
It
employees'
is of commercial
use
value,
are
effective,
copyrighted
or
in order to
potential
protect them from
because of
outside
its secret
use.
nature. It is the
What is
object by
intellectual
its
property?
legitimate holder of
Intellectual
reasonable
property
protection
forms of
measures
employee
in the
creations such as
circumstances
patent
to keep
innovations,
it secret.
discoveries, trademarks.
Thank you for watching our presentation over international employment law, labor standards, and ethics. If you have any questions, please leave a comment below.